Debbie is an attorney who works with academic medical centers, research institutions, and startup companies, particularly those in the life sciences. Her areas of legal concentration are science law, including research misconduct, regulations, compliance, and investigations, healthcare law, and intellectual property. She previously worked at the Office of Research Integrity, the ORI, as an attorney, and now advises journals, institutions, and scientists on matters of research integrity. She's a frequent speaker and author on research integrity issues. She received her JD and BSc in biomedical engineering from Duke University and is a member of the patent bar.
Okay, you're set? Okay, good morning, everyone. So, as you heard a little bit about my background, I feel like I get to see the very best of science because I advocate for new medical technologies all the time. But I also get to see the dark side of science, which is what I'll be speaking about this morning. And kind of, hopefully, when we get into the question and answer session, ask lots of questions. I've been doing research misconduct cases since 1989. Obviously a child prodigy, hopefully you should learn lessons from all the scars on my back and the things that I've kind of seen and watched over the years. And it's actually a very exciting time, I think, particularly for journals in terms of this particular area. I always tell people it's a great promise. I mean, science is so exciting, but as we'll hear, there's also a lot of opportunity for education. Okay. So I'm going to speak a little bit about research misconduct, and towards that, I want to orient everyone because I know we have two crime fighters here with me, and give you a little bit about the history, how we ended up here, and very importantly about what is research misconduct, because unfortunately there's various definitions that might come into play. Talk a little bit about the instance. I'm happy to talk about cases I've been involved in quite a few and work different angles, and then talk about sanctions, because actually the journals have a very significant role in one principal sanctions that occurs when there's a finding of research misconduct. Okay, so how do we get here? All right, now again, back in the early 80s, there were a series of high-profile cases involving allegations of research misconduct. The first one was John Darcy. He was a cardiologist at Harvard, and he was incredibly prolific. He was a rising star. He was producing these incredible number of papers. Unfortunately, he was making up all of his data. Then we had Al-Sabti. Now, Al-Sabti understood that the way to advance in academia is to have a lot of publications to your name. So what he would do was read the better journals, take the authors' names off, and submit the same article to other journals. So it would all be published under his name. So his CV had incredible depth on a number of areas, and in fact, they were published. And every time he got caught, he moved on to just another institution, and no one really spoke about it. And then we have what's known as the Summerlin case. Now, he claimed to be able to transplant skin from a black mouse to a white mouse, and you have this very dramatic picture showing his ability, supposedly. However, it turned out he was not, in fact, performing a transplant. He was simply quite gifted with a black magic marker. So, we had these cases, and this is in, as I said, early 80s, and then little-known congressman from the state of Tennessee, Al Gore, actually had congressional hearings on the issue of research integrity. And he looked at these cases, including the Hans case, and he looked at the scientists and said, what are you going to do about this? We're giving you all of this money, and I've got magic marker on a mouse. And the scientists, kind of looking back at the congressional people and saying, oh, you English and history majors, political science majors, science is self-correcting. Science is a search for truth. We have peer review, we have replication. You don't understand. Our field is pristine, it's pure, it's the good guys. And your stuff is so messy up there. So you have this clash of cultures where you have the scientists a little bit denying that there was a problem. Of course, there's psychos in every field. And the Congress saying, well, not only do you not have a plan to correct this issue when we're giving you all of this money, but you're kind of denying one exists. And with that, the federal government said, every institution that receives federal funding for research for research, must have policies and procedures for responding to allegations of research misconduct. That was 1981. The regulations came out in 1988, 89. And they were predominantly the Office of Research Integrity, which is part of the Public Health Service, excuse me, the National Science Foundation, and then you have these other players, the Office of Human Research Protections, the Veterans Administration, and the FDA. But all of this, the primary federal actors in our country, and there's other actors in other countries, which I will talk about briefly, are the Office of Research Integrity and the National Science Foundation. Just so you know, the FDA recently actually just proposed rules where they were going to require sponsors, not the researcher, not the university or the institution that receives money, but the sponsors of the research to start reporting allegations of research misconduct, because they have a sense that every time an investigator in an FDA clinical trial made up the data, the sponsor, not wanting to alienate perhaps a high prescriber or a high user, would simply drop that data. So you had people who kept moving from one sponsored project to another, just making up the data, and everybody just kind of say, well, Dr. Smith, we had a little issue with your data. We're not going to say anything about it, but we're just not going to submit your data. And so they felt like they were kind of slipping on people. But these are the most active federal players. And again, I'll talk a little bit about OHRP and the VA. Okay, now the definition. So in 1988 and 89, that's when the National Science Foundation and the Public Health Service issued their regulations. They defined research misconduct as falsification, fabrication, plagiarism, and other practices that seriously deviate from those accepted in the scientific community for proposing, conducting, or reporting research. But it does not include honest error or honest differences in interpretations of data. So what happened is, and that was known as FFP with the other practices. But there was a great hue and cry from the research community saying, well, we're going to have a lot of innovative researchers consider other practices, and we have to have this dropped, and this is really unworkable from an evidentiary point of view. And in 2000, the White House agreed, the White House Office of Science Technology Policy, and said it is too confusing, and there were too many difficult cases where they couldn't prove and other practice was a serious deviation. One of the primary ones being the one involving Bob Gallo discovering the AIDS virus. Has anyone ever seen the movie and the band played on? Anyway, so the fact that he wouldn't share the cell line and he obscured the origin of the virus for his own, believed to be for his own professional advancement, when we're dealing with a pandemic, the Office of Research Integrity tried to claim that that was another practice that seriously deviated from that which was accepted in the scientific community. But they couldn't get enough scientists to say that in fact was true. That when you're playing at that level, the elbows are very pointy, very sharp, and that's just how hardball was played. So in view of some of the problems that they had, the agencies dropped the other practices prong of the definition. And now it's simply falsification, fabrication, and plagiarism. However, most of the universities don't dust out, get out their research misconduct policies and update it every time something new happens in the Federal Register. So more than about 50% of universities and colleges in this country still define research misconduct as falsification, fabrication, plagiarism, and other practices that are seriously deviate from those accepted within the scientific community. So what's created is institutions. You can have institutional finding of research misconduct that does not result in a federal finding of research misconduct. And institutions have had great latitude in this. Some institutions say any animal welfare violation is research misconduct. Any violation of any research regulation, so pouring the radioactive stuff down the drain rather than disposing it properly is research misconduct. And human subject violations or duplicative publication. Duplicative publication is not research misconduct under the federal definition, nor is what, salami science, least publishable unit activity. That's not research misconduct under the federal definition, but it is under some institutions within the United States. But that becomes even broader when you start looking internationally. So they're different. Obviously, science is highly collaborative, and in other countries, they will define research misconduct to include all of those other practices, which I just said are exempted from the U.S. definitions at this point. So it's important if you end up with a case that you appreciate which definition, in fact, applies. It also helps you understand why sometimes applying the university, there have been some very high-profile cases recently, making a finding of research misconduct that doesn't result in a federal finding of research misconduct. Okay, so the incidents, the Office of Research Integrity gets about 300 allegations a year. And they make, and this is very interesting just from a pure numbers point of view, that number becomes a very small number of investigations. There's only about 30 investigations of research misconduct a year. So that funnel went from 300 to 30, and they only make about 10 findings a year. So it's a very, a funnel that becomes very small very quickly. And the National Science Foundation also has a lower number, 60 to 100 allegations a year, and historically they only made less than 10 a year, but now they're right about, for some other reasons, they're more about 10 also a year. One of the reasons why the National Science Foundation is making more findings is they are actually subjecting a certain percentage of the grant applications they receive to plagiarism detection software. And so they are catching more, that's just one of their techniques that they're doing. And it's also very interesting. So 90% of the research misconduct findings by the National Science Foundation are plagiarism cases. And less than 20% of the research misconduct findings by the Office of Research Integrity are plagiarism. So you have an exact inverse between the two agencies in terms of their efforts and their focus. And also I think it might be a bit because of the nature of what they're doing. Office of Research Integrity is public health service, so it's more biomedical research. Excuse me, and National Science Foundation is more science. It's interesting. Some of the stuff is really obvious. There'll be broken English, beautiful English, broken English, beautiful English. I mean, you don't even need the software to pick it up. But because they tend to fund a lot of, in the hard sciences, they tend to have more of that type of incidents in their grouping. I pick on the clinical trial cases only because, from my perspective, this is where the fabrication, falsification, plagiarism, whatever, is going to have the most profound impact immediately. Right? It's one thing to say, I had 10 mice when I only had 2. And we've got several levels before it's going to affect human healthcare. But when you're making up things in clinical trials, there can be an almost immediate effect on human subjects. And I thought it was very interesting that roughly a third of the cases that are at the Office of Research Integrity actually involve clinical trials. And I should mention that the Office of Research Integrity, and I'm going to include its predecessor organizations, which was the Office, very Orwellian names, right? Office of Scientific Integrity. They've made about 200 findings of research misconduct since 1989, just to give you kind of a ballpark. And the National Science Foundation has made roughly 50, so really not that many relative to the Office of Research Integrity. But I just gave you examples of the types of things that come up. Falsifying and fabricating interviews, changing the medical records. I don't know if you all remember the big incident involving mastectomy versus lumpectomy. Does that ring a bell for anybody? There was a landmark study published in New England Journal of Medicine where the researchers showed that a lumpectomy for the treatment of breast cancer was as effective as a mastectomy where you remove the entire breast. And it turned out one of the researchers had fabricated data. I mean, we had congressional hearings about all these women who had lumpectomy and not a mastectomy, and this one researcher had fabricated data. And what he had done, it was interesting. He was a researcher out of Canada, Poisson, and he had about 100 patients in this 3,000 plus study. But his argument was, I have these women, and they need to be treated for breast cancer. And the only way they're going to get treated is if they're in a clinical trial, and this is the clinical trial. So to be in the study, you had to have had surgery on this date and be at a certain age, and then you had to have radiation on this other date. And if your dates disqualified you, he simply took white out, changed the date, or in other cases, he literally just took a piece of paper and taped over. So it's kind of like Jeopardy. You flip up the tab and see the real date, and the fake date was on it, and you're sending to the monitors. And his argument was, I'm a physician. I trying to help these patients, and I'm trying to get them in this study. It was actually very interesting. He actually had file cabinets, label on the outside, true and false. But it's very interesting because that was his argument, but he ended up compromising a huge study that affected the treatment of many, many in this country. And it also underscored how journal editors were somewhat disenfranchised from the whole process. Because although there was a finding of research misconduct against Poisson, neither the University of Pittsburgh nor the University in Montreal, nor anybody thought to tell the journal editor that this landmark study involved falsified data. And Marcia Angel was then the editor. She was livid. And she actually published all of the explanations, all of these parties. The first time she found out that that article had falsified data in it was when a reporter contacted her and asked her about it. And she just, appropriately, I believe, was quite upset. And then you can see these other examples: failure to follow protocol, falsification, fabrication, consent form, substitution of specimen, which I think is one of my favorites. There's a number of cases. There was one case in particular where they were studying lead levels in children, in certain tribes in the United States, and apparently small children don't like to be stuck with needles, so they had difficulty collecting the blood. So some of the people involved in the clinical trial took pity on these children and donated their blood. And unfortunately, the blood shows up at another center. These collections were like in Oklahoma and Miami, and it's, postmenopausal woman, hormone, and it's supposed to be a 6-year-old child. So I wasn't really kind of thinking how they thought that was going to happen, but apparently they do that. And then a number of cases involving falsification of consent forms, where they sign on behalf of the patient. Again, just to give you a sense of numbers, this is a little bit outdated, but these are the institutions that have handled allegations and done investigations of research misconduct. And so the institution that has the greatest experience only has 23 investigations in about a 23-year period, just to give you a sense of the numbers you're dealing with, which also explains a little bit about why, when there are cases, they tend to make missteps. If you only do something once a year, right, you're not going to be as proficient as if you do it all the time. And you see as you go further down, the numbers get smaller and smaller and smaller and smaller. So most institutions do not have great experience. I think that's important to you because if you're looking at institutions, because what you'll end up with is dealing with the corrections or retractions of a paper or handling manuscript that's in the middle of this. Just be aware that there's not a lot of depth at the institutions, although, unfortunately, and that's a good thing, right? You don't want them to have a lot of experience with it, but also because the other way, and they don't have the same familiarity. And this is just an aside. These cases are always messy. In addition to the misconduct investigation, there's all these internal processes. The FDA can be coming down. There's criminal investigations. There's civil litigation. A lot of other pots are boiling at the same time you're having a research misconduct. When there is a finding of research misconduct, there are many types of sanctions that are applied. There's an institutional sanction, which typically, all right, you're not eligible for promotion, you could get demoted, you could be asked to leave, you could have your degree rescinded, whatever. Then there's what the Office of Research Integrity does, or the National Science Foundation does, which generally is for 3 years, you either have to agree not to seek federal funding or to be subject to a plan of supervision, which is a more normal, common. Not that you are cut off from federal funding, but that somebody has to watch you for a 3-year period. And there have been a series of now criminal convictions involving research misconduct because you get the money in, and the money came from, let's just say NIH, got wired to your institution. Now I have wire fraud, regular fraud. And then what has also happened now is what's known as the False Claims Act. The False Claims Act is an act that dates back to the Civil War, which allows every citizen in the United States to bring a lawsuit on behalf of the government. And it comes back in the Civil War. The Union was buying all these supplies, and people were being mobbed. And the famous case was they bought 500 donkeys for the effort, and it turned out the donkeys were blind. And so what ended up happening is we didn't have enough attorney generals in our country, so we basically said, any citizen who brings forward one of these lawsuits on behalf of the government, there's going to be a bounty. So if you submit a claim to the government for, based on false data or information, the damages the government's going to get is 3 times the amount. well, these grants are not for $10, right? So if there's a $100,000 grant or $1 million grant, the allegation is going to be, I want $300,000, and that's what the government's going to assess against the institution, whoever the recipient is. Oh, and the sweetener for the person who took this on, this part of the concerned citizen, is they get 1/3 of the take. So if I'm some poor researcher, and I know so-and-so made up that data to get that grant, it's a $100,000 grant, and I bring this forward under one of these False Claims Act cases, I literally can sit pretty. The Department of Justice does all the depositions, they do all the work. You just sit back and wait for your $100,000 check to show up. So it's become a little bit of a lottery for those who, hear about these types of cases. So it's invite a little cottage industry. Now, a couple of things. Whenever there's a finding of research misconduct, these are some of the things. The notice in the Federal Register, nobody, I don't think, reads that with their Cheerios in the morning. However, it does mean that a person found guilty of research misconduct, their name will perpetually be out there. You type in their name and it pops up. The Federal Register notice making you found guilty. Debarment means you can't receive federal funding for anything, and that's kind of a nuclear weapon. And again, it would typically be 3 years, and that is government-wide. So if you're found guilty of research misconduct, not only can you not get federal money for research, you can't get an FHA loan. If you're a physician, Medicare, Medicaid can't reimburse for your services. You can't get a student loan. And it is a government-wide department. And also now, there's recovery of funds. Now the agencies are going back to universities and individuals and saying, you got this money and I want it back. And that's unfortunate because a lot of innocent researchers typically live off of a grant. So the fact that there's one bad actor results in a huge payback hurts a lot of people. And that's actually a very difficult decision for university administrators when they have to give back a large sum of money. And the one that will affect you the most is going to be the correction of the literature. I mean, so let's say one person committed research misconduct. It's just fascinating watching all the other authors, like, I'm the victim too, I'm indignant, and other people say, no, you should be responsible, you stood up to collect the glory, you should be there to go down with the fall. And the arguments and negotiations going on when someone's going to try to correct the literature, either by retraction or correction, or it is just amazing. I mean, are you going to point to the person and just say, we had no idea, we're so sorry, or some journals say, no, your eyes together, you fall together. So there's a lot of philosophical questions here. And I think as journal editors, or people involved in publishing, you have to make some decisions. Philosophically, what do you think? Rise together, fall together? Or will you allow someone to assign blame so that that person moves on to another institution or another place, that that person is held accountable by the scientific community? Because if you think about it, I mean, Francis Collins, he had an underling, Hashra, 17 papers had to be retracted, right? We're going to wipe out Francis Collins because he didn't have better oversight of Hashra. He didn't detect it. And I say it's interesting. I think we all need to debate that within ourselves, because if I have an associate give me a document, she says, these are what the cases say, I have no reason to think she's lying to me, right? And science is built on trust. It has to be to a certain degree, particularly when you look at the international collaborations. And you see what happened in the stem cell case, right? That one researcher's in Korea, one's in the United States, and was it feasible for him to actually go to Korea and look at the cell lines, or should he be able to trust a person who'd been a long-time collaborator that he wasn't lying to him? And then kind of look at the fallout of that. What did we end up doing? Did you think there was a just result on it? But again, in the area of correction for literature, you will be heavily engaged, because now that's one of the big issues. And then I only have like 2 more minutes. Actually, lawsuits have been filed against journals involving allegations of research misconduct. Copyright infringement is obvious when there's an allegation of plagiarism. Also, false passing off, which means I didn't know I was an author. You put me on this paper, and so you misportrayed me. If someone gets dropped as an author, they could say, you journal editor should have known, and now you've ruined my chances of opportunity to get other fabulous appointments or elsewhere. Intentional infliction of emotional distress, and then a couple cases I've seen conspiracy theories, right? That the journal editor was conspiring with the nasty, evil co-authors who left you off, and you're trying to do all this. So it gets a bit messy. And I bring all of that up because, I always tell people, it's kind of like an audit. Maybe you sail through the whole thing, they find absolutely nothing. But the process is the punishment. And so, unfortunately, I want you to think about these things ahead of time so that you can be prepared if one of these cases comes up. And I think I have ended it at exactly my time, and I think I'm going to take questions, and I would certainly encourage you to ask a lot when we get to the end.